Good afternoon, everybody. So firstly, I'll read out the Chairman's introduction and then we'll begin through the items on the agenda. So firstly, this is a meeting of the Council held in public. It is not a public meeting. There is no fire drill planned, so if the fire alarm sounds, please leave by the nearest exit or the exit nearest the large screen at the front of the room and proceed down the fire exit to the courtyard. Once it is safe to return, councillors will receive a text message. Officers will also advise when it is safe to return to the meeting. We are recording the meeting this evening, or this morning, or afternoon rather, using our webcasting system. The webcast will be transmitted live and will also be available on the Council's website following the meeting. All mobile devices should be switched off or set to silent so that the meeting is not interrupted by ringtones. And certainly for those in the public gallery, generally the public seating areas are not filmed. However, by entering the meeting room and using the public seating area, you are consenting to being filmed and to the possible use of those images and sound recordings for webcasting and/or training purposes. Anyone intending to film or audio record any part of the meeting is asked to do so in a manner that does not disrupt the meeting. So please refrain from filming the public gallery. So on to the agenda items. So agenda item 1, apologies for absence. Emma, any apologies for absence? No. Lovely. Agenda item 2, declarations of interest. To receive any declarations of interest from members in accordance with paragraph 9 of the Members' Code of Conduct. Is any interest for committee members to declare? No? So, yeah, no interest to declare. Emma? So item number 3, minutes. Confirmation of the minutes of the Licensing Act 2003 subcommittee held on the 15th of May 2025. So we'll hold the vote for the formality. All those in favour? That's 2. Abstentions? That's 1. Emma. So agenda item 4, the Licensing Act 2003 subcommittee hearing procedure. And I'll run through the procedure as detailed on page 17 of the report pack. So in all, there are 10 steps that we'll go through as part of the procedure today. Those being the opening of the hearing being step 1. Step 2, the licensing officer will then proceed to present the report. Step 3, the applicant will put their case to the subcommittee. Step 4, any responsible authorities present will then be invited to speak. Before going on to step 5, other persons at that point will be able to state their case, and following that the chairman will structure and lead a discussion on the information presented, enabling subcommittee members to clarify any points raised and ask any questions if necessary. And then moving on to step 7, summing up. So I will then ask those present if they have any final comments to make. At step 7, these comments can only be in relation to our issues raised during the discussion, and no party can provide new evidence at that point. Step number 8, final clarification. So licensing subcommittee members will have a final opportunity to seek clarification on any points raised, following which the chairman will conclude the discussion. And then in the penultimate step, step 9, the subcommittee will withdraw to consider the evidence that has been presented to them with the governance officer and legal officer in order that the subcommittee can reach a decision and obtain legal advice if required. And then the final step, step 10, the chairman, myself, will announce the decision. So I think as we open the hearing and obviously move on to agenda item 5, Licensing Act 2003, application to vary a premises licence, the Crown, 2 High Street, Billericay. I think if we do a round of introductions, so I'll start with myself, Councillor Andy Ansell, the chairman of the Licensing Committee and obviously chairman of the subcommittee meeting for this afternoon. And we'll run through the committee members to my right.
Councillor Valerie Robbins, I'm the Deputy Chairman of Licensing.
Councillor Hazel Green, Licensing.
Thank you, Hazel. To my left.
I'm Teo Hassan, Legal Representative.
Thank you. Emma Perry from Governance Services.
Roy Robinson, Licensing Officer.
Good afternoon. My name is Piers Warren from TLT Solicitors and I represent the applicants Green King here today.
Joshua Gibson, and I'm the tenant of the Crown in Billericay.
Yes, I'm David Daz, I'm councillor. I'm here to represent the tenant.
I'm James Pearson, the Business Development Manager for Green King.
Duncan Beat, a resident in nearby to the Crown Public House.
Joanna Patmore, resident. To local. Do you want to come over here?
Maureen Hardy.
Say, Maureen Hardy.
Oh, sorry. Maureen Hardy. Resident just at the back of the Crown.
Thank you, Maureen. Or with that,
Sorry, Chair, I do apologise.
yes, Mr. Dads.
I didn't catch the gentleman's name from the residence. Is it possible to be repeated?
Sure.
Duncan Beat, B-E-A-T.
Thank you, Duncan. With that, over to you, Roy, to present your reports.
Thank you, Chairman. Before I go to the report, over the weekend and this morning we've received some additional documents which I've already shared with you. I just was wondering if you would be willing to accept those documents for everyone to consider. We can supply them to the other persons here to make sure they've all got them. So it's over to you, Chairman.
Yes, thank you, Roy. You're happy to admit those, and I think probably for fullness as well, worth noting that these kind of part of that evidence also includes a video recording an incident outside the Crown pub on the 13th of December 2024, taken at 11:15 in the evening, and I think that films an incident in which there was assault on security staff of the pub, and the police were called. So just to kind of note that, and yeah, Roy, you're happy to admit that, and I think probably worth if you verbalise the nature of that evidence that has been admitted.
Thank you, Chairman. They're emails that obviously you have a copy of, and obviously that we can pass it round to everyone if you're happy to have a short recess to actually look at those, and everyone can have a read of them to take it in what they actually say, if that's okay with you, Chairman.
Thank you. Speaking personally, I don't feel the requirement for a recess, but unless any of the subcommittee members feel differently, or the other persons or the applicant feels differently.
Chair, we're more than happy to crack on. We've had a look at them, and they build on what's said before. There's nothing new there that I can see.
I think it would be helpful to clarify who exhibited the CCTV which resident.
If that's possible.
So
Roy,
yes, it was I believe it was. I did actually search you on the. Have you got the link there? I haven't got my.
Yep.
Chairman, so, obviously the other residents haven't had a chance to see the papers that we received over the weekend, so I wonder if we could circulate to them and whether they'd like a chance to read them, Chairman.
Yes, so certainly as I went through the rounds, if the other persons wish for a short adjournment to review or to view that information.
Yeah, there seems to have been quite a lot of information come to you. Is that on the back of Joshua's statement?
Yeah, I believe so. Yes. So we're happy that the licensing officer will provide you with copies of that now, and happy.
So this is everything that's received, plus there was a video on top of this?
Yes.
Right.
The video came.
Is the video very long?
No, it's two very, very short clips.
Then is it possible just to show it to us so we know what it is?
Can I take some?
Oh, this is mine.
Yeah, we might want some time to go have a look at all of this.
This is my email.
So, yep. So I think if the other persons feel it be beneficial, if they take a short adjournment of say 5 minutes for you to review the information that's been submitted just prior to the meeting, and you can view a copy of that recording that the committee have received. If that's agreeable with you, that's what we'll do. Yeah, I think you can do that. There's obviously kind of a waiting area outside, of course. So I think with that, we'll have a short 5-minute adjournment, and we'll come back at, say, what, just gone 20 past? Or actually, for fullness, yeah, come back at 25 past. Thank you. So before we proceed after adjournment, I think there's one or two extra introductions to do, and then we'll resume. We'll hand back to Roy. So starting actually on our left with a licensing officer.
My name is Alex Mascus. I'm the licensing manager for Basildon Council.
Thank you. And then another other person on the front row there. Thank you, Elaine, and the two gentlemen in the second row.
Andrew Somerville, resident.
Richard Keane, resident. Sorry, Richard Keane, and I'm a resident.
Thank you, Andrew. Thank you, Richard. With that, Roy, please do proceed.
Under the Licensing Act 2003. On the 25th of April 2025, the Licensing Authority received an application for a variation of an existing premises licence from TLT Solicitors for the Crown 2 High Street, Billericay, on behalf of the licence holder Green King. Although the premises licence is held by Green King, the premises is managed independently by Mr Joshua Gibson, who lives at the premises, and Mr Gibson is also the designated premises supervisor. The application was accepted as being properly made and has been advertised in accordance with the relevant regulations. The application, Enclosure 2, requests to amend the hours the premises open and permitted to undertake licensable activities on Fridays and Saturdays. Non-standard timings will be added to match these hours. The new hours will be as following. The open hours will be Friday, Saturday, 0700 hours to 0230 hours. On Christmas Eve, Boxing Day, Maundy Thursday, Sunday prior to a bank holiday, Monday New Year's Eve, 7 till 2:30. The next morning, licensable activities, the sale of alcohol, live and recorded music. The times for these will be Friday and Saturday, 0700 to 02000. Christmas Eve, Boxing Day, Maundy Thursday, Sunday prior to a bank holiday, Monday, and New Year's Eve, 0700 to 0200. Late night refreshment, Friday and Saturday, 2300 hours to 0200 hours. Christmas Eve, Boxing Day, Maundy Thursday, Sunday prior to a bank holiday, Monday, and New Year's Eve, 2300 to 0200. This is also an application to amend Condition 7 of Annex 2 of the licence. The current Condition 7, a minimum of 2 SIA registered door staff, will be on duty from 2000 hours until the premises closes on Fridays and Saturdays, when regulated entertainment is taking place. This is not applicable to the restaurant, and it shall now read as follows. A minimum of 2 SIA registered door staff will be on duty from 21:30 hours until the premises closes on Friday and Saturdays, when regulated entertainment is taking place. All other hours, activities and conditions are to remain unchanged by this application. The current licence contains the existing hours and conditions attached as Enclosure 3, and a plan showing the location of the premises is attached to Enclosure 4. During the 28-day consultation period, the Licensing Authority received no representations from responsible authorities. However, Essex Police and Environmental Health Pollution Team have agreed some additional conditions with the applicant. These are shown as Enclosure number 5. The Licensing Authority received 56 representations against the application from other persons, Enclosure number 6, and 12 representations in favour of the application from other persons, can be seen at Enclosure number 7. Recommendations. The subcommittee considers this report together with any oral submissions given at the hearing from the applicant and others making relevant representations before determining the application for the variation of a premises licence. The options available to the committee are the options available. The licence authority must have regard to the application and relevant representation, take such steps mentioned below, if any, as considered necessary for the promotion of the licensing objectives. the licensing authority, having regard to the representations, either grant the application as applied for, modify the conditions of the licence, i.e. alter, omit or add conditions, or reject the whole or part of the application, and for this purpose the conditions of the licence are modified if any of them are altered or omitted or any new condition is added. With respect to point B above, any modification must be relevant to the variation proposal under consideration. For this application, the proposed variation is as follows. All licensing activities indoors only, extension of hours from 0100 hours to 200 hours on Fridays, Saturdays and during non-standard times, and the opening hours, extension of hours from 0130 hours to 0230 hours on Friday and Saturdays and during other non-standard times. Thank you, Chairman.
Thank you for that, Roy. Firstly, I'll come to the subcommittee members, see if they've got any questions or points of clarification for you. I'll start off with myself relating to the representations you mentioned during the 28-day consultation period, and you said that Essex Police and the Environmental Health Pollution Control Team have worked with the applicant to agree some additional conditions. I think just to be clear, there's no objection from Essex Police or the Council's Environmental Health Team.
That's correct, Chairman. Thank you.
Thank you, Roy. Councillor Robbins, Councillor Green, any questions, points of clarification?
No.
And in that case, I think we'll go to the other parties. So does the applicant have any questions or points for the licensing officer?
No questions. Thank you very much, Chair.
Mr. Dads?
Could I ask the licensing authority to confirm, as a responsible authority, they didn't raise any objections either?
No, the licensing authority did not raise any objection.
Other persons? Duncan, any?
Sorry, not being a lawyer and not actually fully understanding everything that was said, but you talked about the police report, they had no, and the environmental health had no objections. All right. All right. Sorry, it was just, I'm not a lawyer and I've never been to one of these, know nothing about these type of applications, and we obviously, on our right, we have...
Do you have any questions
to
licensing officer?
Just the, the Essex Police report and the environmental health, so they did a report, did they?
Roy will clarify.
Thank you, Jim. The Environmental Health Department, Pollution Team, and the police would have had copies of the application, and they would have looked at the application and discussed their concerns, if they had, or what concerns they had. They would have just discussed them with the applicant.
But so they wouldn't have been looking at the objections. So you don't say, and here's the objections, and this is why, so that the environmental health can come round and say, well, what I'll do is I'll have a look. I mean, if you'd have asked any of us, we'd have said, well, have you taken this into consideration?
I'd say, Duncan, I think if you're relating to comments made by kind of Essex Police or other consultees or responsible authorities that have looked at the case as itself, in terms of, I'm just making a judgment on the application and the permission it's seeking, rather, they're basing it off of that.
Chair, they had their own records that they would have consulted before making a decision.
Can I just ask, did they not look at the records that they had from the last hearing, where there was a 2-page document about how they didn't see that it was a good thing to have with the noise late at night and how it affected people? Was that not considered?
On the last hearing, they actually withdrew before the hearing, so both on the Environmental Health and Police never made any representations on that occasion either. But obviously they would look at the relevant evidence that they feel they need to look at. Not being an environmental health officer or a police officer, all I can say is they had the application and they've obviously considered their points.
So they don't look back to see what's done before?
I say I'm not a police officer, I'm not an environmental health officer. They would have looked at the records they felt that were correct to look at.
I thought you were environmental.
I'm a licensing officer, I'm not an environmental officer.
Sorry, I've got confused. Okay.
And I think at this point it's worth being clear that each application is considered on its own merits. I think that's probably quite important to say here. Mr. Dads, is there something you wanted to say?
Yes, I think in my speaking note, paragraph 5, I say all applications should be considered case by case. We respectfully submit that the previous application not directly related to this one, and that obviously the responsible authorities will look at this one, but as you were seeking points of clarification, they'll look at the council's complaint list or database. The police will do the same with the police records, and then it's that they form their basis whether they believe this application will undermine. And it's worth saying that they are duty bound. If they thought that licensing objectives were undermined, then they would object. So following the principles of Daniel Thwaite case, you have to take into consideration. I won't repeat that for later, but it's worth saying now since we're discussing it.
Thank you, Mr. Dadd. So, is there any other, I'd stress, questions or points of clarification to the licensing officer at this point? You'll have, as I mentioned during the procedure, other persons will have you'll have your point to state your case in full. So, at this point, any questions to the licensing officer?
Yeah, sorry to labour the point, but perhaps I'm missing it. The police have been asked to look at the application, and they had no objections to the applications. They weren't actually saying that it sounds like a good idea, let's grant that. It's just we have no objections at this moment in time, but no representations have been made to them. Or am I missing something? You'll have to
They've had the application and they've made no objection. I can't speak for Essex Police, but they've made no objection.
They made no objection.
Yeah.
So, and there's a written report to this effect, is there somewhere?
I don't have it. They've just made no objection to the licensing department, which is how they would make it. Yeah, this is how it works. They would look at the application, as it said. They would look at it on its own merits. This is an individual application. They would look at it. They make a decision whether what their paperwork they've got inside the police. They just email me saying they have no objections.
Right, and therefore they're obviously leaving it up to to your good selves to actually make the decision, of course, and that therefore takes into consideration everything else. They have no objection to the actual application, but that would probably be the same for any other application that was being made.
It doesn't matter. I think what they say about any other application. Sorry, Duncan. What we're interested in is this one.
Yeah, of course. Yeah, but they just So basically, no comment from them. Fine. Okay, now I understand.
Unless there's any points, I think we'll give the gentleman in the second row, Mr. Somerville and Mr. Keane. Is there any questions or points of clarification you have for the licensing officer? Lovely. In that case, then we'll move on to step 3, the applicant's case, and Piers, over to you.
Thank you very much, Chair. Just so that everyone's aware, if it's okay with you, Chair, what we'll do is we'll divide this into 2 parts. So effectively, I speak for the applicant for Greene King, and I'll deal with an overview of the application and the points that were made, and then Mr. Dadds, who is here with Josh, will be able to speak to some additional points. Seeing myself on the screen behind you both is really disconcerting. I think I'm going to have to start getting hair and makeup before I do licensing committees if we're going to keep doing this. The application has 2 parts to it. As you've heard from Roy, it's set out on pages 20 and 21 of the papers, just so that we're clear as to the 2 parts separately. The first part are the changes to the hours on a Friday and Saturday night only, to 2 a.m. rather than 1 a.m. And then the high days and holidays, as were mentioned. And then the second part of the application relates to conditions. There's the amendment to condition 7 of Annex 2 of outdoor supervisors starting slightly later than earlier, as you'll have seen, and then also the conditions that were agreed with the Environmental Protection Officer and the police can be found at page 59 of your papers. And there's 3 conditions there. One of them actually builds on this condition 7 in terms of actually having to have a risk assessment for additional door staff on the Friday and Saturday. The second part relates to a more robust Challenge 25 policy, which builds on a condition already on in Annex 2, Condition 2. And then the third one is about having body-worn video. A minimum 50% of door supervisors must have body-worn video. So those were the conditions that were agreed in advance. In terms of the police and environmental protection not making representations, I think it goes slightly further than that, because obviously the assessment they make, as Mr. Dadds has referred to, is to whether, in their opinion, it would be appropriate or proportionate to object to this application. So it's not like condition where we have the members of the public where I won't sit here and say, well, because not everyone in the localities objected, therefore you can say they support us. You can make that assessment with the responsible authorities, because they do have to go through a process and determine whether or not they think this application on its merits would undermine the objectives. You'll be pleased to hear actually that Josh spends an awful lot of time speaking to the officers and dealing with them on a day-to-day basis. So that's licensing, that's the police and environmental protection, and in fact I'll touch on some of the works that he's done in my submissions. So it goes further than them just looking on the papers and making an assessment, if you like. It's based on the history, it's based on their work with Josh and whether they believe he can operate this licence to the modest extensions we're asking for on the Friday and Saturday. What this application does not do, and I think this is very important, it does not affect the use of the premises garden in any way whatsoever. The reason I mention that is obviously a lot of the representations talk about the use of the garden and events therein. Those are irrelevant, and my submission is that actually they need to be discarded, and there is case law to that effect, which if you wanted me to go into we could discuss, but it's High Court case law that says actually this isn't a review of the premises licence. Anything that's not part of the application, let's park. If you do want my... Yeah, okay, great. So you don't need me to go into the case law, that's great. It also does not remove any of the protections that are in place on the premises licence already, so those will continue through the additional hour where you're minded to grant them. So that's incident logs, dispersal policies, CCTV, doors and windows closed during entertainment, and a phone number for residents. Feel free to obviously ask any further questions of Josh about this, but in terms of people asking for numbers so that they can make complaints directly to the premises, the number is 0. The number of times he's given out the number to people who've come in and he said, let me give you my number, is those people who come in, like a new resident who came recently, and other people, someone who's a landlord of 4 of the residents nearby, he gave his number to them as well. So he's proactive in giving out the number. He's not been asked for it, but that's been a condition on the licence for some time now. I'm going to talk in general terms about the representations, because obviously there is a number of them, but they do touch upon some points, some of which in my submissions are irrelevant. I'll ignore those. If you have any questions about the bits I ignore, we can discuss whether they are relevant or not in terms of this determination. But in general terms, I'd break them down into 5 areas. One is music outbreak from inside the premises, one is dispersal, allegations of drug dealing and allegations of heavy-handed door supervisors. I'll take those, I put them separately, but I'll take them as one. Rubbish thrown into gardens and customer safety and intoxication. So those are the 5 areas I've identified relevant to these later on. And there are a number of representations that will say, well, nothing's changed since 2022. Why on earth are we back here? Respectfully to those comments, I disagree wholeheartedly with that. Firstly, financial and trading conditions have changed to a degree that it's very difficult to explain in this environment quickly. But you'll know about things like the rate changes, you'll know about NICs and various costs that have gone on to operating premises. I'm a trustee for the BII, so can talk authoritatively to 13,000 members they have who run pubs. 80% of them are not expected to make a profit this year. That is the situation that all publicans find themselves in trading at the moment. So an additional hour of trading is not actually simply just saying, well, an additional hour gives a little bit of extra revenue. It has quite a significant effect on the operation of the premises throughout. Customers will make choices at the start of the night and they'll decide, well, actually, we think we want to stay out past the time the premises can open. We need to go elsewhere. So they won't come in the first place. Or indeed, if they're having a good night out, they might say, well, we'll want to go on somewhere later. We need to leave now to get somewhere later, especially given the fact that that means going somewhere else entirely geographically. So it has quite a significant effect on the revenue of the premises not having this additional hour in terms of its current revenue and future revenue streams. It has a knock-on effect in terms of other businesses. You'll have seen that referenced in a representation. It has knock-on effects in terms of staff and job security. At the moment, Josh employs 10 staff directly. It was more than that, but costs being what they are, including the door staff cost from 8 o'clock, which is very prohibitive given the numbers that are in at that time, just simply means he has to cut his cloth accordingly. So it has a very real effect on employment. DJs, as a former DJ myself, I quite like that little extra revenue coming in once in a while at the weekends. Door team, obviously, they get employment, and he has 2 in-house security staff that work with him for 8 years. You'll have seen representation saying, well, because of the number of security, surely that shows what a terrible place and that it must be. Well, actually, we'd argue the other way, and I think the police would as well. So it promotes the licensing objectives, and he does the right thing in having a good and robust number of security at the premises. Complaints directly to Josh, none. Outside of one event, outside event that elicited some residents going to the environmental protection officer, and they came in. There was an agreement after that for one event a year. It's not relevant to this, but we want to be open and candid about that. Close liaison with the police environmental protection officers, and I will submit the fact there's no representations from them needs to be given significant weight, and I'll quote the guidance in my submissions at the end. You'll note from the reputations in support, there's talk of improvement in the operation and past reputation, and certainly before Josh's time as well. He's been there for a significant time. He's worked very hard to improve it, but he took on a site that certainly had a very poor reputation when he came into it. And I think it's worthwhile noting that there has been a 3-year period in which he took stock. We didn't, appeal the decision that was made then. He took his time, gave some thought to it, proactively engaged with all the officers, and has come back now, given that there were no complaints and given that was a point that was raised regularly at the last hearing, and with officer support, we say, and certainly Josh says, time is right now to come back in those circumstances and to put a case before you today. And thirdly, and this is a point that gets a little bit of, it's dismissed, I think, slightly lightly, if I can say that respectfully, by the residents. This is something that's driven by customers. One doesn't open later in the night if you can do everything you can do earlier. Everyone wants to go to bed a bit earlier, but actually this is driven by customers. In particular, in Billericay, there is very little in terms of nighttime economy for which people can go to, and as you'll have seen from Josh's statement and other comments as well, absolutely nowhere if you're between 18 and 25. Now that is the legal age in which you can go out and drink. It's also the legal age in which you can go out and enjoy a bit of dancing and fun, and by no means should these people be dismissed because they're young. I mean, frankly, lots more young people nowadays drink a lot less than I did in my days in the 90s. So actually there is a sea change in what people want, and that includes going out and going to places where they can dance and enjoy their time. So being forced to go elsewhere and outside of the town actually is quite significant. So they are asking for this. Managing people on site actually promotes the licensing objectives because you want to have people in early, you want them to stay, you want to be able to manage them. He's got a robust door team, he trains all his staff, and you'll hear about training from Mr. Dads later. You get to make sure that they're safe and act in a proper manner. So the specific issues in terms of the 5, and I'll go through these very quickly and then pass on to Mr. Dads. Garden events aren't relevant. Internal music. In April 2025, Josh went out of his way and paid for a professional noise report, which he then sent to the environmental protection officers prior to the application being made. Now, the fact that they haven't made a representation, given the information that was given to them, is very probative in a matter such as this. Now, we didn't submit the report because they're technical things, but also actually they tend to garner as, filling places with documentation ask more questions than sometimes they answer. We gave them to the experts your environmental protection team. They are happy with it. They found that music outbreak from the premises was minimal. They found also that actually good practice was in place, such as searching people outside and then admitting them in groups so that the doors were open less time. So rather than letting one in, one out, as a group, in you go and out you go. So good practice. They also found that other premises were directly responsible for music noise that could be overheard, anything coming from the Crown. And indeed, your officers no doubt would be able to tell you, and Mr. Dads is a very experienced solicitor here and in the town, would be able to tell you about other premises and significant noise issues that are very nearby. Dispersal. There is a clear dispersal policy in place. You've seen that there's a condition on the premises licence. There are reports, and the officers come in and they do check Josh on what he's doing, so they're obviously satisfied with what's in place there. Section 182 guidance, as you well know, is very clear at paragraph 2.27 about people being responsible for their own behaviour away from the premises. There are other premises in Billericay. It's challenging, and I think, again, Mr. Dadds may touch upon this in terms of where residents are, to suggest that actually the dispersal issues that are complained about and concern people coming later would come from the Crown, certainly from an evidential point of view. The video, which now everyone has seen, from the 17th to the 12th, so we're talking 7 months ago, I think that's my maths is right on that, is not an example of undermining the crime and disorder objective. And I can say that with some confidence. The main assailant was ejected from the premises quite lawfully. He chose to get violent. The door staff acted accordingly. Police were called. He was restrained. Evidence was provided to the police. They did everything they could to support them. And you see the last bit of that video is the police officers controlling someone who clearly just didn't want to be controlled. So the premises dealt with that properly and effectively, and indeed the police were very happy with Josh's response. The 1 a.m. last entry time will obviously have a big effect on venue hopping, if you want to call it that. And indeed, actually, it adds to the half an hour that currently sits on the licence by making it an hour-long last entry time. Before then, you have the last half an hour, drinking up time and getting away. So it's 1.5 hours for which people who are already in the venue, no one will be added and they can disperse. Drug dealing, we simply do not accept the allegations. Candidly, and the police work closely with all venues. Systemic issues of drugs are not relevant to this committee. Josh has got robust measures in place. The toilet attendant is a good example of that on a Friday and Saturday night. Someone there who is there to dissuade people from taking drugs. Anyone found with or taking drugs is immediately ejected and barred. And I would challenge anyone to suggest that there is evidence of systemic drug issues related to this premises. Same for heavier-handed door staff. Door supervisors are there to do a job. They're very nice and welcoming if you behave properly, but if you don't behave properly, their job is there to get people out safely, keep their customers safe, and manage them that way. Rubbish thrown in gardens. Drinks aren't permitted out at the end of the night, which is enforced. Now, obviously, we can't talk to or be held responsible for takeaway rubbish. There's 3 takeaways in the very immediate vicinity, etc. So again, I'm going to sort of, if you like, park that, unless there's specific evidence to suggest branded glasses from the premises are there. It's impossible to say evidentially that is an issue for this pub. And customer safety and intoxication, well, again, I've already pointed out to the fact that actually keep people in, keep them here. We know who they are, we can deal with that and manage it well. Wave training is something that David will mention. It's part of the training that his staff does, which is all about vulnerability and keeping people safe. So it's taken very, very seriously. Those are my submissions. A bit of a canter through. There are some specific issues that I think Mr. Dadds wants to take you to, and then maybe after that, I'd invite you to ask any questions at that stage. So.
Yes, and thank you, members, for the indulgence. It's unusual to have 2, but I'll try not to repeat what my learned friend has said. But as I said earlier on, and your legal advisor said it as much, is that each application must be on its own merits. The members of the public have written in, and of course you'll look to those representations, but you have to consider them with the appropriate weight. Firstly, I think we have 48 residents have not attended. And following the principles of Daniel East Gwent, what weight you attach is something for you to consider, because the maker of the statement is not present. I have had a look at the representations, knowing the area very well. I do know that there are about 30 that are not nearby, that can't be affected by noise breakout or people dispersing the immediate vicinity. And there's a list provided. I mean, for example, High Gloucesters, Low Gloucesters, Cloisters. You've got also Cromwell Avenue, Lake Avenue, and the like. You've got then 2 residents of Norsey Road. Norsey Road is a large road, and I think you've got number 24, and it goes up. And I would say that they can't be affected by what is going on, or if they do or hear something, there's not a direct causal link. So it's a general observation. Then there are 12 representation from Grey Lady Place, and we know that officers from your council have attended in that vicinity and not witnessed any noise breakout that can be directly linked to our premises in any way. And in fact, I think French Martini, who's another premises nearby that's no longer trading, we're having lots of complaints about noise breakout, and being slightly elevated, it might carry over the train tracks. But certainly, we have not had any direct causal link of any noise breakout, and the way that our door's positioned, the way it faces, we say that that's de minimis and not likely. And then we have 8 from Crown Road, but yet again, you've got to go down Crown Road, and the way it goes down, we would say that if there's noise, French Martini, given how it is on Norsey Road, it can carry or going across. But you've got the railway, you've got people leaving the railway station, people dispersing in and out of the town. You've got Myra, you have all the other restaurants around the premises. So it might be of a general nature, but obviously specifically to our premises, there is no complaint specifically tied. And certainly no representation made by a resident has been supported by either Environmental Health, the police, or the licensing authority. The gentleman talked about that the police have made no comment. It goes much further than that, and as my friend said, the police licensing authority as well as Environmental Health, they have their own databases. So the residents that are here now, if they've made a representation or a complaint in the last 12 months, it will be of their record, because obviously, for example, if Mr. Beat has made any complaints to Environmental Health, he'll tell us how many he's made in the last 12 months that directly links to our premises, and if the officers have been there and made a direct tie. And I would say that there's likely that chance is de minimis, otherwise they would have raised the objection. Carrying on, we ask you to perhaps focus on those steps about promoting the licensing objectives, and that's where the police and ourselves have looked at the conditions offered, and we believe that they promote. I've said evidence-based, East Gwent, and also the Daniel Thwaite case talks about looking at that evidence objectively. Point 7 of my paragraph repeats what I've already said, but what we also have said is that we have engaged with the responsible authorities, as you would expect us to do. The conditions are summarised in paragraph 8. We've always acted professionally and courteously with our neighbours. In fact, we have a number of neighbours sitting behind us who I would say that one of the gentlemen from number 3 Norsey Road, directly behind, doesn't raise any complaint about the way that we manage the premises or operate. And in fact, I think even Mr. Beat comes in and drinks within the premises. So the reality of it is that we are community-based. People do come in, and I think it's important to recognise that. A lot of the complaints are away from the immediate vicinity, I would hasten to add, and not being tied. It is important to recognise that Josh, if I can use his first name, has been operating the premises for over 10 years. So he's got a proven track record on how the premises operate. He's invested significantly in the premises and believes it is important to provide a community asset. Now, obviously some of us here do not go out late. I don't go out too late. But there are some in our community that do want to go out, younger people, even yourself, councillor, right? So the reality of it is that Billericay has changed over the years. We used to have the premises up near Langdon Road. The name escapes me now because I haven't been there for. Reeds, that's it, yes. Yeah, we've all been there years ago with different names, but that's now closed. There are other premises that have closed. People sometimes used to go to Brentwood, and some of those premises are now closed. So for younger people that want to go out, and certainly I wouldn't say this application is late, 2 o'clock, everyone can buy to 2:30. then it gives them an opportunity to go out and enjoy themselves, but it's also in an environment that is safe and correct. And it's the right location. It is in the high street location. It is at the end of the town, right next to the railway lines. The trains are running till late. And it is in town. So if you live on the edge of town, you will know that people will come and go from town. Now, you won't know which premises they're coming from, but we do have a dispersal policy. We do manage that. And I think there's always that balance to be struck. And Friday and Saturday, it's not unreasonable for a premises like this in a town centre to be open to the hours that we seek. And as I say, there are no objections from the Environmental Health about noise. In relation to training, the applicant takes very robustly the need to train and is a member of Licensing Connect. I know I've mentioned this to you before, but in essence it's an independent training provider. It does the welfare and vulnerability training, licensing training, and it gives the premises the refusal to register, incident books, accident books, etc. So it has a very robust system of recording, training and how it operates. It has policies and procedures, and we recognise that they're not just a tick box exercise, they're actually undertaken and carried on. I think unless there's anything particular, I would say that this application has gone through a very robust scrutiny from the responsible authorities. We understand there will be some hesitation from some residents regarding the increase in hours, but we say we say that that what the measures that we put forward do promote the licensing objectives. In relation to the incident my learned friend raised regarding the video clip, firstly, the person that's exhibited is not present, and I don't actually think that from there where they live in Norsey Road, because we were told it was number 1324 Norsey Road, it's not possible from that angle. You'd have to have come out and gone all the way down, and it's not immediately, but I think it's been circulating on social media. But I think there is a recognition, and we recognise that sometimes things do happen on licensed premises from time to time, and it's how you deal with that and how you manage that. And obviously the police are fully aware of that clip, and they were there present, and they believe that we acted responsibly. There are time to time that you will have to deal with matters arising, and it's how you deal with that in a professional way that we have. So we've been quite open, and the police are aware of it. So, and as I say, away from the premises, as my friend says, is the responsibilities of individuals alone to be law-abiding, unless there's any questions.
Thank you, Mr. Lads. Thank you, Mr. Warren. Yes, certainly we'll move on to questions and points of clarification now. Certainly we'll start with a subcommittee. Councillor Robbins, Councillor Green, any points for you on this week, should we? In that case, one or two for me. I think I'm right in saying that, Mr. Warren, during your comment you said that certainly the conditions that have been agreed with the Essex Police and the Council's Environmental Health Pollution Control Team, that was partly born out of a result of a proactivity on the applicant's part, going to responsible authorities first, rather than waiting for them to comment or raise concerns.
Exactly that, Chair. So sort of, if you like, for a little timeline, Josh obviously liaises with James at Green King about applications, but Josh independently had already gone and sought police. Well, he speaks to them regularly, and licensing and the environmental protection officers. They suggested, in conjunction with Josh, to do a noise report so there could be no doubt about noise outbreak, which he then did. And it was after that had been submitted and dealt with that then, if you like, I got the final instruction from James to submit the application.
Thank you. And another one I think it's mentioned in the report, and I think you've highlighted kind of verbally, kind of the training that goes in for that is invested in staff, and I think probably particularly pertinent to this point, given the representations that have been made from residents regarding the SIA training for security staff. Can you kind of explain for the subcommittee kind of the difference that makes between kind of a, say, someone that has that accreditation and someone that doesn't?
Yes, with the SIA, a door supervisor has to be trained regularly. Recently, that they've all been mandated to have restraint training, welfare and vulnerability engagement training, and typically it's hands in pockets approach. So it's about de-escalation. And they are professionally trained and registered, and we only have registered SIA door supervisors. And we have the correct ratio. In fact, we probably have more, but that's proactive to ensure that the licensing objective, prevention of crime disorder, is upheld. And obviously, then we obviously manage that. So they have their training, and then we train our staff regarding licensing, engagement, conflict management. So we do that internally for our own staff, and then separately we have the WAVE training, which is the welfare and engagement, to ensure that women and girls and other people with vulnerabilities can go out safely, and if they raise any concerns, that our staff are trained to pick that up, whether it's asked Angela or asked for help or assistance, or someone's found on their own, or whatever that may be. And we record that in our refusal register, instant book or vulnerability book. So we have all our records kept, which I know that Martin from Essex Police has been in, and we've discussed it before with him. So obviously he's fully aware of the safe practices and systems we have in place.
Thank you, Mr. Dads. And one more as well, sticking on the theme of security/door staff. I know obviously one of the kind of conditions you've agreed with Essex Police is around the minimum of 2, but I note that sometimes the kind of DPS might consider putting more door staff on. It'd be interesting to know kind of if there's any more the kind of applicant team would like to mention around the thought processes in judging door staff, staffing numbers on the door. And I know particularly one of the those kind of agreed conditions relates around when the start time. Is there kind of a standard kind of end time for those door staff?
If I start with sort of, if you like, the basics of it, and then it might be for Josh to sort of go into the nuanced details of how he has more door staff than the minimum that are on. We've added in the risk assessment element. You'll have seen from the licence that there were 2 door staff conditions anyway. One said the minimum of 2 from 8 o'clock. We're amending that to 9:30, which just reflects customer numbers. But that doesn't mean if you were to have a busier night or the football was on or something like that, you wouldn't have door staff earlier. That's the minimum requirement. That cost element over that hour and a half can be very significant if you add it up and over months of having door staff in with no one there. So that's very much a minimum requirement. We've added in an additional risk assessment element for the Fridays and Saturday nights, so that there is, if you like, a documented record of how often or how many door staff and when they start and end. They have to end after the customers have dispersed as part of good practice. So you know, you don't close the doors and everyone's gone. You help with dispersal. In terms of the actual numbers that Josh puts on, I might just hand this over to Josh to give you an overview.
So on a Friday night, there is 8 members of security, which is 6 above the 2 that we are stated to have. And on a Saturday, there is between 5 and 7, depending on what is available and what is going on the high street. Take a look at other premises of what they're doing as well, and we take that into account of what our security team needs to have and how many numbers we provide.
And can I add to that, what we've done is with the start time, we've had those discussions with Essex Police, and as you know, that they're the main source of advice on crime disorder, and they haven't objected to the change of the start time.
Thank you very much for the extra information. It's most helpful. Probably nothing further. No questions or points from me at this point. I'll take if the subcommittee members still have nothing they wish to ask at this point. I think we'll give the other persons present an opportunity to kind of ask any questions to the applicant team or their representatives. So unless there's anything you'd wish to ask or seek clarification for now, we'll move on to the next step.
I wanted to say something about the objections were, you were saying that they weren't close to the pub and that people in the cloisters wouldn't be affected. They are raised up, so therefore they are level with the pub. So therefore
Certainly,
they would
I'd ask kind of direct questions rather than kind of comments or
Right,
statements
oh,
at this
okay.
point. Sorry, just to
questions.
clarify, yes, you've got any direct questions? So it seemed based on the case that the case that they put before everyone.
Not actual questions, just statements.
Maureen, something you'd like to say, Maureen? We'll come to you kind of once we have any questions or points of clarification, then we'll come to yourselves to kind of state your case. So unless there's anything further, I mean, Councillor Green has a question.
I don't know actually if speaking to anybody that knows about it. The noise abatement. Do you have anything special on the noise abatement? Would you have a special room where, you know, when you have live music or your recorded music, is there such? Do you have that as an extra or anything like that?
We don't have a noise limiter, but
No.
we have had a acoustic report carried out, as
Right.
you heard, and we did that prior to the application.
Right.
And your environmental health officers have had a look at it and are satisfied.
Oh, good.
I can say that we know that with regards to Grey Lady Place, that officers have attended historically at the back to see whether we are a noise source,
Yeah.
and they are satisfied we are not. So therefore, we don't believe there is a noise breakout, and that the residents will not be disturbed by us playing recorded music.
Okay.
And there's no evidence to say
No.
otherwise. And in fact, there's evidence to the positive, because I say that the Environmental Health would be duty bound to raise an objection if they thought the licensing objective or prevention of public nuisance was undermined.
Yeah. Okay. Thank you.
Any further questions, Councillor Green? No. Thank you. Well, in that case, unless there's any kind of questions or points of clarification for the applicant, we'll move on. So I know there's no responsible authorities present now, so we'll move on to step 5, the other person's case. I'd like to mention to the residents, I know that there was no time limit placed on the applicant team and the speeches that they delivered, so I will not do so for you, although I'd naturally ask that please keep your speeches concise and to the point. So I know there's multiple people wishing to speak. Is there an order in which you'd like to speak, or unless I'll just kind of call you and we'll kind of go along the row? So, yep.
This is just...
Over to you, Maureen.
Right. I just want to say this. I've got nothing against your business. I wouldn't want to do any harm to your business. But the current closing time of 1 a.m. is already enough. I feel later time of 2:30 will devalue our properties, increase antisocial behaviour, noise, shouting and loitering. Also vandalism, street drinking and even crime. The neighbourhood is home to many young families and elderly residents. Children will be disturbed. Our community deserves an environment that supports rest, safety and peace, not late night noise and insecurity. I want to preserve the character and safety and quality of life in our neighbourhood. It's just, you know, to think of it, I mean, it's already loud. I don't think you realise how loud it comes across to us. It's so easy, and the older people, sometimes we have to go and see if they're all right, and then you've got children that, so it's not, you know, it's not because I want to damage your business. I'll be up to help you, but not, you can't extend it to ridiculous hours.
That's good. I think Maureen summed that up quite well. I just have a couple of things to add. The environmental officers came round in April, 13th or 14th of April 25. I saw Josh walking past with the sound person in the afternoon, late afternoon, and then he came back about 4 times between, I don't know, 10 and 2 in the morning. And obviously, because he's employed them, he's not going. The noise in his pub is not going to be that as loud as usual that night because he's got them there measuring. But they're walking along the front of the houses in Grey Lady Place. But the noise is heard at the first level, bedroom level, at the back of the houses, which face the pub. So he's not capturing the noise that's heard. He's capturing the noise that's down on ground level.
Carries over.
And there's a block, there's houses in between. So he's not getting the right measurement of noise there. So that's one thing I wanted to point out with that. Getting the people round to listen to the noise, and it was, it was okay. It wasn't okay. Just recently, I've been woken up in the middle of the night, 12, 1 or 2 o'clock, not 2 o'clock, sorry, 12 o'clock, 1 o'clock on a Saturday night, by the beating, the bass beating. My house faces where his outdoor pub area is now. I think there's a marquee just been erected there. And I understand the music is inside the pub and not outside, but I'm still hearing it. It's a loud beating noise. So Sunday morning, I'm up at 6 o'clock in the morning. I've got things I need to do. I need to get a good night's sleep because I'm doing athletics. And I can't get that sleep. And if it's extended, I won't be getting to sleep until 2:30 at least. So that gives me not even 4 hours sleep before I have to go and compete. So that's just where I am, but it's for the whole area. Like, we're representing, there's only 4 of us here today, but we are representing many people that are at work today. Not everybody can get time off work to be here. So although they're saying, oh, there's 56 objections, but there's only 4 people here, that's because luckily we can be here, and other people have asked us to say certain things for them. It's like last time the Environmental Health were saying that they didn't think it was that it wasn't a good thing to have this licence extended, and they went on to say about health-related impacts. Exposure to such noise leads to immediate effects such as poor mental health, contributes to stress, stress-related illness, high blood pressure, sleep disruption, emotional disturbance and with low productivity. It seems now that they don't seem to have that opinion, but they had that opinion 3 years ago. And I can't see how that's going to have changed. And also, talking about change, the pub is still where it is, the houses are still where they are. Yes, it's located near the station and the high street, but it's also surrounded by houses. It's going to impact so many people not being able to get to sleep because of the noise. And a lot of the objections talked about the car parking down Crown Street and things being thrown in their gardens. Yeah, I know you can't say it's coming from the Crown residents, but it's coming from people that have been drinking for a long time. Sorry, that's about it, I've got to say.
I suppose just following on from that because we did hear that on these, if this is more, we're talking about dispersal, and the dispersal at the current time. It's we're saying it works, and that's fine. Add another hour plus on top of that, then we really will see it's coming from the Crown, as opposed to we heard earlier perhaps it was coming from the Myra restaurant, which is very, very unlikely, as that doesn't open until after 11 o'clock. So I failed to see that some of the other venues that were being mentioned as where the substantial noise or the crowds is very unlikely. You'd have to know Billericay perhaps to understand that. As I said, I actually do drink in the Crown. I hope I'm not going to get banned now, but
No, we will. Don't worry.
I don't think adding an extra hour, it doesn't seem like much, but again, I think the point's being made that the costs, it needs the extra money to cover the extra costs of rising, which we all know for all of us, the extra costs for just general living. So I appreciate that, but not at the expense of the people. Sorry?
I live in High Cloister.
And you hear it.
But not at the...
Yeah, sorry, I'd like Mr. Beat to be heard.
Yeah.
Let Mr. Beat finish and then you...
Yeah, but just not at the expense of the people that live around by. I think, you know, none of us are moaning about the, making too much of a thing about the current licensing, but we all feel quite strongly that there really is no need to add on this extra hour and a half, and we really do think it will make, I mean, the solicitors who spoke earlier very eloquently, and you know, our friend here from the brewery, we are not professionals, and therefore we haven't spent hours and hours going up with this. So a lot of this is coming from here, but how it's going to affect some of the older residents and the kids locally nearby, and we think specifically all those that are not represented here, and those that actually, believe it or not, have not even heard that there is such an application going on. I know it's advertised somewhere in the newspaper. I'm not exactly know where. I never saw it. Somebody happened to mention it to me. I don't think anybody. I mean, it is advertised, isn't it? In the little Gazette notice, presumably.
Yep, there has been obviously a statutory consultation that's been undertaken. I think it's probably worth bringing in Roy here to answer that question directly, as you've raised the consultation that's been undertaken. So Roy, can we bring you in?
The application is advertised at the premises with a blue notice, in a newspaper and on the council's website.
And there was a leaflet put round by residents. So
Yes.
It was flooded the area.
Okay.
I will confirm. I have seen the leaflet that was paid.
The legal obligation has been met around, kind of consultation.
Regulations, the advertising.
Thanks for clarifying that, Roy. Mr. Beat, back over to you.
I would think we would all agree that the legal obligations have been fully complied with. Yeah. What I'm trying to say to you is that even though they have, I didn't see it, and I like to think I'm relatively observant, and I even, as I said, go into the Crown pub because I like it, and I like the manager here, who I think has done a wonderful job locally. So, you know, I think all the residents would feel the same. We know he does stuff for the community, so there's no animosity or bad feeling there whatsoever. But we still think that this is going to adversely affect the local community. It doesn't matter how you want to say, no, it's not the Crown, the music isn't coming from the Crown. You know, I'm afraid to say, you know, we're going to disagree on that point. Yeah, they've had the environmental people round to walk round, and we live there, and we hear it. So we can't. We're going to disagree. Should he have an extra hour and a half that time in the morning? We think not. I mean, I think that we put most of our case to you, specifically in writing. Yeah, and that's probably all. You know, I've got to say on that. Have you got anything further?
And over, I'd say obviously we've had 3 speakers so far. Elaine, certainly, obviously happy for you to speak. But is there anything in particular, anything new you'd like to add in addition to the kind of the evidence and the cases put by the
I'd
residents?
just like to start by saying I agree with everything that's been said. For me, I live in High Cloister. Look, and I want to reiterate some of the things that Maureen has said, and it's nothing against the business, and I'm not against people staying out late. I don't always want to go home at 11 o'clock or whatever. I just think it's just not in the right area, and I agree with Maureen. I mean, I think it will devalue our property, to be quite honest with you. I'm all for having, people having employment, and people, especially younger people, having a nicer time after, 11 o'clock or even 12 o'clock. But I just think it's too late too often and too close to a residential area. And for me personally, I live in High Cloister, and they nearly all park, not all, but a lot of people park in my road. It is chock-a-block. And there's a parking bay right opposite my house that holds 6 cars. And what I've had quite a lot of is they sit in their cars with their headlights on main beam, and they light up my whole house really late at night. I can see people, because I've got a Ring doorbell, I can see them in there. If I put the microphone thing on, I can hear they're arguing in there sometimes. I mean, I did call the police actually a few months ago. I couldn't tell you the date because I didn't. If I would have made a note of it had I known this was coming up. But a car arrived at 11 o'clock, and they sat with their headlights on main beam, lighting up my house for over an hour, and then they drove off at 12:05, and half an hour later they came back. I mean, for me, I live on my own. It's not the first time it's happened, and it doesn't happen every week, but I started to get really panicky about that, and I did call the police. But they didn't come. She said, well, they haven't actually done anything, and by the time we get there, they might have gone, so they didn't come. But I was getting a bit nervous. I'm not saying they came from the Crown, I don't know, but the fact that if it's going to be every week, why 2:30 in the morning in an area like that? I mean, come on, you're employing extra security, toilet attendants, so you're not expecting to be drinking lemonade, are you? They're going to be pissed, aren't they, quite frankly? You know, a lot of the time. And
yes, sorry, Elaine, I kind of asked you to be a bit more considerate of the language that you
Sorry
use,
about that.
and I'm obviously conscious that...
Well, obviously... Yeah.
I'm sorry.
Do you hear the noise?
Yep.
Where you live?
I just clear to say
Well, yeah.
issues around noise, antisocial behaviour, claims around crime have already been mentioned by our neighbours. So
Well, I
we've
just
had 3
think-
speakers before. Elaine, if you give me one moment, if you could rate, if is there anything in addition you'd like to add, any additional licensing objectives you'd like to speak to, which you feel would be jeopardised by the permission or by the approval of this application?
I'd like just to add that they do use empty their rubbish out of their cars. I find beer bottles in the front garden. It's been used as a toilet. Not every week, but quite often. And I've lived there for nearly 8 years, and I don't really want it to get any worse.
Yeah, that's it. So certainly, before I go to the other members of the subcommittee and then the applicant for any kind of questions or points they have, I think although you didn't raise them specifically, am I right in thinking it's probably fair to say that the 2 licensing objectives you were talking around that you feel would be undermined should the application be approved relate to the prevention of public nuisance and the prevention of crime and disorder? Are those the 2? Is that fair to characterise what you've mentioned? And I think probably one question from me, in the evidence that you've given to the subcommittee, I think focuses, almost entirely on anecdotal evidence. Is there any kind of hard evidence you'd like to present to the subcommittee or talk about relating to number of kind of police call-outs, number of kind of police complaints, any evidence from decibel monitors that back up the claims that you're making around noise, ASB, crime, for example? I'm just asking to substantiate the claims that you're making with cold, hard evidence. I thought you'd wanted to talk to the evidence submitted by a local resident that was the filming of that incident on the 13th of December 2024, relating to a kind of an incident where the police were called outside the pub. Is there kind of any additional evidence around that in terms of crime, police involvement, decibel monitors around unacceptable noise levels that you'd like to talk about?
I don't think we actually have any evidence. After the hearing last time, I reported noise carrying on. That was in September 22. So that, although there was a statement saying there had been no complaints whatsoever, there were complaints after the hearing, but that was September 22. I stopped complaining because I realised that if I wanted to sell my house, I'd have to disclose I'd had a dispute with my neighbour. And so therefore I stopped making complaints to the council because I was thinking of moving at the time, and I knew it was going to affect the sale of my house. And also when I did complain, it didn't stop the noise. I had to stay up late and have the environmental health people around my house to listen to the noise from my bedroom. Being on my own, I felt uncomfortable doing that. I didn't like to have a man in my house, in my bedroom at midnight, listening to the noise, just him and me. So I stopped the complaining and put up the noise, stayed out, slept elsewhere, used earplugs, did all kinds of different things, played white noise, and I'm suffering. But it's still going to, but I don't have any hard evidence. I don't have the recording of it. Like you said, like a monitor. I don't have anything like that. So unfortunately there is no hard evidence, it's just what I'm saying.
Yeah, I think to be fair for us to actually go out and actually buy a monitor and start doing that, we probably didn't know at the beginning of this that we'd be required to, but we probably should have done.
Yeah. But there was the reports that I've made to the Environment Health after the hearing, so there have been complaints since the last hearing, so that is not a true statement. And I've got
but
it
I
here.
do think that if we'd have known that, then of course the other side, of course, spent a lot of money on eloquent solicitors, which is one would expect, and somebody from Green King to come along again, eloquently speaking, and spending a small.
Yeah, but that's the cost, isn't it? That's the problem.
I'd say it's worth pointing out here that obviously this is a quasi-judicial process. Obviously the clue being in judicial, and I think it's probably worth saying that obviously commercial, both the applicant team and other persons so far have raised kind of commercial arguments in favour, whether that's I think property prices or the commercial performance of the pub. I'd say that arguments based in licensing objectives are the ones that I think carry real significant weight. Commercial arguments, I think it might sound rather callous for me to say so, but I think are generally viewed as carrying less weight given the matter before us today, and obviously the fact that it's a quasi-judicial process. I think, Mr. Dadds, I know you want to come in. We'll come to.
Can I just say one more thing? As a result of the hearing last time, there was 2 reasons for the application being dismissed. The second reason says, given the location...
Joe, I know, I'm sorry, I've said this repeatedly before, that, and again, I don't mean to be difficult, and I know that it's been raised a number of points during the hearing so far, that each application is considered on its own merits. Okay. What we're considering is what's before us today, the case that's before us today, the representations before us today.
Nothing has changed in the way that the pub is situated where it is and the houses are situated where they are. So
I'd say that, Joe. Happy if you want to kind of repeat the point again that you wanted to make. Happy for you to proceed, but I wanted to be clear for the record that unfortunately this is what the subcommittee has to consider and make a judgment on.
Just very briefly, so it gives it a balance. That I think it's not just about lawyers being present and that we can afford it, the residents can't. There is a safety net, which is the residents can call the police service or Environment Health, and that's free. We do know the Environmental have been there in relation to historically, and they have not been able to tie a link. I think there's been issues with French Martini and others, but not ours. And I welcome the comments that the residents say. It says, we can't say it's from them, from us.
Mr. Bear with me a second, Mr. Dadds. Yeah, sorry, Mr. Dadds. Yeah, like the legal officer has rightly said, any kind of points to, rather than additional...
It's only because they were getting into discussion. I thought I wanted to try to balance it with a couple observations, but I'll pick that up on the closing.
Thank you, Mr. Dadds. So we'll go to the other members of the subcommittee if you've got any questions or points of clarification to the other persons that have just spoken.
No.
No, lovely, nothing from me. The applicant team, I know the other persons had an opportunity to cross-examine yourselves, so I'll give you the same opportunity now.
I have no questions, but thank you for attending and making this.
That's what I'm going to do. Thank you. So I know obviously there are two other gentlemen on the second row, Mr. Somerville and Mr. Keane, obviously present as other persons. I'll now give you each an opportunity to speak and address the subcommittee if you wish.
Okay. Andrew Somerville. I'm probably the closest neighbour. I'm back onto the premises, and I've spoken to Josh many times and haven't had a reason to raise anything. I do drink in there occasionally. If I had a problem, I'm sure Josh would answer the phone to me because we have a friendly basis. I have no noise issues. I've got double glazing. Bear in mind, I'm literally backing onto the premises. With the windows shut, double glazing, I don't have any issues sleeping or I've got friends over, they don't have problems either. I would have thought as literally the nearest neighbour, I would have the most reason to complain, if I did.
I'm also quite not as close, but I also live fairly close to the premises in Radford Court. And yeah, again, obviously, sometimes throughout the summer months, I might have my window open, but I've never had any issues where the noise has been that bad that it stopped me from sleeping. And I know that Josh has a policy of telling his customers to respect the neighbours when they leave the premises, when they go in home. So I've really got no issues with noise at all. And obviously he's very approachable. You know, anyone can go up to Josh, talk to Josh about any issues. So no issues there from me. Thank you.
Thank you, Mr. Somerville. Mr. Keane, I think it's probably worth mentioning as well that obviously your testimony is kind of rooted in anecdotal evidence, the same in the interest and fairness. I think a kind of question for me, back to you, and obviously having heard the applicant team talking around the measures that are in place to promote the licensing objectives, I'd invite you, is there anything you'd like to say around the measures that have been put in place to promote the licensing objectives?
No, as far as I'm concerned, they seem logical and fair.
Yeah, I'll agree with that. You know, I've got no objections to that at all.
Sorry. In case there's any more, unless there's any more questions or points of clarification for the two gentlemen that I've taken spoken in support of the application, we will move on. And I think it's probably fair to characterise the debate and the discussion of the hearings so far. Certainly focusing on those points, I think we've heard from the applicant team around the measures that are in place to promote the licensing objectives, the lack of an objection from any of the responsible authorities, and how actually I think to avoid that, the applicant has proactively worked with Essex Police and the council's environmental health pollution team, and obviously conscious, I think points around those agreed conditions with the applicant and the Essex Police and the council's environmental health team. And I think obviously probably the debate and discussion so far centring around the two licensing objectives around the prevention of crime and noise nuisance. And I think that's obviously the focus of a lot of the debate we'll have later. So I think I'll invite the other members of the subcommittee to say if there's any kind of extra points you want to get clarification on from anyone you've heard so far, any questions you've got before we'll then sum up. In that point, then I think we'll go to summing up. And I think perhaps Mr. As, I know you've indicated your starts. If we start with yourself, the other persons, and then of course the the licensing officer as well. And then I think we'll go to final clarification and consideration. I think important to say.
Normally, I think normally, Chair, it would be the residents first and then the premise licence holder or the applicant last. So if it's possible, residents first, me, and then last word, perhaps the solicitor for the pub company.
Fair enough, Councillor Dads. Thank you for pointing that out. And I think probably
Councillor Dads again.
Sorry, Councillor Dads. Sorry, for the record, Mr. Dads. Sorry, Mr. Dads. Slip of the tongue. Conscious. Obviously, neither party can provide new evidence at this point. So, other persons, there's kind of any kind of summing up you'd like to do on the evidence you've submitted already?
Well, you've heard everything that we've already said, so it's going to be the same thing that we're going to say, just that the pub is very close to the houses, although the two gentlemen were saying they live, one of them lives on the back. Maybe he goes to bed later, maybe he doesn't get up so early, people have different lifestyles. But there are an awful lot of people that that have been affected by this. Or will be affected, and you can see that by the amount of objections. Okay, yes, some of them may have been from further afield, but even High Cloister, which is further afield, it's raised up, so therefore it hears it. It's going to be the residents leaving, the patrons leaving later is going to affect the neighbours, the residents. And with regards to people's houses and people using them as toilets and the front gardens and all the rest of it, we can't pin that down to the Crown, but it could be them. There's not, you can't say who that is. I know that, but it's the noise. It's the noise that's going to affect the people. Did you want to say anything?
No, only that the car park was taken away. And,
So there's now a marquee there.
It's loud from that now as well, because that's...
People sit outside. They sit outside in the marquee in the garden, which is not the garden. It used to be car park.
Now it's connected.
Okay. That's anything. Unless there's anything further to say, then I'll move to the other persons present here. So if there's any summing up you'd like to do, Mr. Somerville. Mr. Keane? If not, we'll move on. Okay, in that case...
bear in mind, also, there's a lot of young children in the area.
Thank you, Elaine.
It will be disturbed.
So you're moving on. So Mr. Somerville, Mr. Keane, nothing further from you. In that case, we'll move to Mr. Dads and Mr. Warren for summing up for your position.
So very briefly, obviously your decision will have to be evidence-based, and that the residents are aware that they can call Environmental Health and others if they so wished, and there's no evidence to support any logs or calls or anything like that, primary evidence I would say. Also, there's no responsible authorities who would be duty-bound to raise those objections. And as I said earlier on, I welcome the candour of the residents, because they say that some of the things that they complain of they can't say comes from us or attribute to us. The Grey Lady Place you'll see on your map, it's not a route where you can walk through as a dispersal. It's across the railway line, and you would have to walk down Stock Road or quite far down Norsey Road to even cut through, and it goes through to nowhere. It would just go from one Stock Road to Norsey Road, so therefore there's no reason to cut through. You've heard the resident from High Cloisters. You were asked directly about whether you can hear noise. The answer was no, and we agree. The residents also said that Mr. Beat said we have no issues with the current licensee. So they have no current issues, and I think that is a reflection of the good operation that Josh does, and that's borne out by no objections. And in fact, I think that one of the residents says he does a wonderful job locally, and he does. And I expect what it is, it's that fear of what might be, and that's not one of the grounds of the licensing objectives, and what it might be or could be. And likewise, it can't be about value of one's home. It's about licensing. And it has been well advertised. It wasn't just the bare minimum. There was leaflets around and the like. So I'd ask you to, attach appropriate weight to how many people have attended, what evidence they've given as primary evidence, and take a view as a whole. We say with the conditions in place, and not only do we say it, but the responsible authorities agree with us that we will promote the licensing objectives going forward. And one last thing is I apologise to my learned friend because I've probably said most of the things he was going to say.
You may have seen me furiously crossing out bits of my final submission, so I'll try not to repeat anything. I think there are a few other points that maybe I can just draw upon. Very pleased to hear the support from residents for Josh, and you'll have done many of these hearings where that isn't always the case, so thank you. But first and foremost, thank you for being candid and open about it. And I think it's fair to say Josh is very open and approachable, as you've heard, and would happily give his number to any of the residents now, so that perhaps if there is an issue where someone says, I'm being waken up by bass noise, which may not be easily apparent from somewhere else, it can be investigated immediately rather than us waiting for something like this to find out about it. Paragraph 9.44 of the guidance specifically states the authority should aim to consider the potential burden that any condition would impose upon a premises licence holder, such as the financial burden due to restrictions on licensing activities, as well as the benefits. I mention this because obviously it was a point that came up, and it's not our key point. You're not here to determine whether his business should succeed or not. That's Josh's job. But you are entitled to take into account the fact that this, for the reasons we've expressed, will actually help support a business. Where, in Billericay, there is a lack of nighttime economy, especially for people who are 18 to 25. There's no allegations or evidence of underage issues associated with this premises, which I suggest in your deliberations you take very highly, given the nature of the premises that Josh operates. And it shows the mark of the operator that is the case. Paragraphs the video from December 2024 is not evidence of a systemic issue, and we've explained why that is, and you've asked the question directly and not heard any evidence to suggest otherwise. And indeed, any public nuisance has to be linked to the premises, and respectfully, we struggle to get direct evidence of that today. Away from the premises, we've dealt with nuisance directly, so I don't need to touch upon that. Your policy, however, is very clear and very robust on this at paragraph 9.6, where you do go into the primary mechanism for licensing is not to deal with public nuisance away. And in fact, you go on to express all the other measures that are in there. And at paragraph 9.7, you recognise the cultural, social and business importance that premises and events requiring licences can provide. This is offering something that people in Billericay are asking for, because they can't get it in Billericay at the moment. The benefits of granting this application for what is a modest increase on a Friday and Saturday night are a safe and well-managed venue for people in Billericay looking for somewhere to go and socialise and dance, which is a public safety issue. EH support for the music levels within the venue. Josh has taken the time to commission his report. That's a public nuisance and directly goes to public nuisance. Dispersal with the last entry time, which is later on the Friday and Saturday, as I explained, you get a longer dispersal period than you currently have. That is a public safety nuisance and prevention of crime and disorder positive here. And the additional and amended conditions, clearly they promote the licensing objectives. The close liaison with the council and officers, paragraphs 2.1 and 9.2 of your guidance, as your legal officer knows, and you probably hear every time, they're the experts. They have determined whether there needs to be representations made, and they've determined in this case that is not the case. And for those reasons, I submit you can grant this application as applied for, with all the conditions as we've discussed. Thank you.
Thank you, Mr. Warren. We'll move to the licensing officer. Is there anything you wish to add, Roy, and anything you wish to sum up?
Thank you, Chairman. Nothing to add.
Thank you, Roy. In that case, obviously, step 8 of the 10 steps of the procedure for the hearing. Obviously, final clarification. So, do any of the licensing subcommittee members, kind of any point, or is there any clarifications you'd like on any of the points raised? If not, I will conclude the discussion.
conclude, I'm fine.
Lovely. In that case, then, the subcommittee will now withdraw to consider the evidence that's been presented to them with the governance officer and the legal advisor, so that we can reach a decision and obtain legal advice if required. So, if I can ask everybody now to leave the room while the subcommittee. Well, in that case, we will be moving, and we will be back once we've reached our decision. Thank you.
Do we have time to go out, or is this going to take long? Roughly how long?
No, I've got it off the internet because I showed it to
Oh,
you before. They
roughly
came.
how long?
I can wait. If you can go next door, so it'll be hanging around, I'll be able to try and find you.
So welcome back, everybody. Thank you for waiting while the subcommittee deliberated and came to the decision. Of course, the committee has now come to a decision, and I will now proceed to read out the decision notice in full. So, decision. Application to vary a premises licence, The Crown, 2 High Street, Billericay. The subcommittee is aware that it has to act to promote the licensing objectives as set out in the Licensing Act of 2003, and that any decision it takes or conditions which it attaches to a licence must be appropriate to achieve these objectives. In reaching its decision, the subcommittee has taken into account the relevant parts of the written and oral evidence before them, the relevant parts of the Council's statement of licensing policy, and the relevant parts of the guidance issued by the Secretary of State. The subcommittee has determined as follows. So, the decision. To grant the variation of the premises licence for the extension of hours from 130 hours to 230 hours on Fridays, Saturdays, and during other non-standard timings. Please refer to Annex 1, the operator's mandatory schedule, and Annex 2, the conditions, with the following amendments. Number 7, a minimum of 2 SIA registered door staff will be on duty from 21:30 hours until the premises closes on Fridays and Saturdays when regulated entertainment is taking place, not applicable to the restaurant in brackets. And number 11, no admittance of new customers after 00:30 hours Sunday to Thursday and 01:00 hours Fridays and Saturdays and during other non-standard timings. All other hours, activities and conditions are to remain unchanged by this application. The reason for the decision. The subcommittee did not feel that after hearing all the evidence provided by all parties, both orally and in writing, that it was sufficient to justify that the licensing objectives of crime and disorder and public nuisance would be undermined. Date of effect, 7th of July 2025. The right of appeal. There is a right of appeal against this decision to Essex Magistrates Court. An appeal must be commenced within 21 days, beginning with the day on which you receive notification of the decision. Ability to review. There is an ability to review, or ability to apply for a review of the licence to the licensing authority after a reasonable interval. You will need to supply evidence of an effect on the 4 licensing objectives. Forms are available for completion from the licensing authority. And with that, that is the decision notice read out. And I think with that, I'll bring the hearing to a close. And as there are no other applications on the agenda for today, I'll bring the meeting to a close. So I'd like to thank everyone for their attendance and wish them a safe journey home. Thank you.
Thank you.